For everybody here, a new law came down the pike a couple years ago. It's called MBTA Communities Law. It was part of an economic development bond bill and was overwhelmingly approved in the legislature and honestly caught pretty much all of us by surprise. It applies to 175 cities and towns here in Massachusetts that are considered MBTA communities. And to clarify, one of the biggest questions I got is, well, is it because of our train station that we are considered an MBTA community? And the current commuter rail service, while it did slightly change our category, we were an MBTA community regardless. We've been an MBTA community for decades. So as you can see from this map, long before the pilot, we were in that map. But I will explain the implications of that change as I keep going. One of the things we all want to acknowledge is that this law came out and it's a mandate from the state. We're hoping that tonight, people are upset and we get that. I don't know if you've all followed Milton, but this is all, we get it. And right here from our side, we're trying to do our best as sort of the government to comply with a law that we weren't asked, we were told. So tonight we hope not to get into the merits of the law, but try to explain our rationale on why we're approaching it the way we are. And it's going to be up to the voters at town meeting as to what happens. So just to give an overview for MBTA communities, we are required as a town to adopt zoning for multifamily use as right. That means you can't require a special permit or any sort of discretionary approval. We have to have at least one zoning district of reasonable size. The minimum gross density of units is 15 units per acre, which, not going to lie, it's very dense. It has to be no more, the bulk of it has to be no more than half a mile from a commuter rail station. And there can't be any age restrictions on the housing. A lot of times we all say, well, senior housing or the 2 bedrooms, that type of thing. Those are subtle ways of kind of creating age restrictions. We're not allowed to do that. And the housing has to be suitable for families with children. So that's all within the law. So what does this mean for Foxborough? Foxborough is considered a commuter rail community. So that is where the commuter rail has affected it. When the law first came out, we were considered an adjacent community because we didn't have permanent commuter rail service. With that, we were required to zone for 768 housing units by right. By being classified as a commuter rail community, that number has increased to 1,152 units by right. So it's based on the 2020 census. So we're looking at having to create zoning to allow 1,152 units within the town of Foxborough. The key to point out here is that we're not mandated to build these units. This is a zoning requirement. It is not a build requirement. So slight nuance. Probably doesn't make anybody feel better. So what is it? It's not a production mandate. That's what I was just pointing out. We don't have to create those units. We just have to zone for them. It is not related to 40B. One of the very frustrating things about being in Foxborough is that Foxborough has done a great job with 40B. We followed all the rules. And in fact, with Walnut Street, once that built, and if Moore Street was built, we would be at over 14% when only 10% is required. That doesn't help us, unfortunately, in this mandate. The law does not supersede the Mass Wetlands Protection Act, nor does it supersede Title V or the Mass Environmental Code. So there will still have to be compliance with all those requirements. And there is no provision for waiver. There's no way out. They don't care that Foxborough's done a great job and that we, many times around us, I was with someone yesterday who has 4% of their affordable housing. We have 14. Doesn't matter. It's a one-size-fits-all. We echo the frustration. And if you've seen any of the planning board meetings, they've had those very conversations. So in the law, it makes clear that towns that do not comply with the requirements will be ineligible for many state funding programs. The Attorney General doubled down and said that she would be looking at civil enforcement and that we cannot avoid the obligations under the law just by saying, that's fine, we don't need any state funding, we're good. Obviously, none of us know how this is really going to play out. I mean, Milton is going first, but I know I was just with the Milton Town Manager yesterday, and the squeeze is on for them. I think the state is kind of going to use Milton as an example because they don't want to lose this whole thing right now when all the towns are going this May or this spring to their town meetings. We've also been told that we run the risk of being sued under the federal fair housing laws. Again, we don't know. We've spent plenty of time with town council. No one knows exactly what's going to be play out. So what we're doing from this side of the table is following the steps required. And it goes to town meeting. Here's this week's notice. You know, the Milton voters reject the new housing plan. The Healy administration has already revoked their grants, and then the Attorney General has already threatened legal action. So by December 31st of this year, we have to submit the zoning district, and we have to comply with the requirement. We've held numerous discussions and meetings on this, including joint meetings with the select board, and came up with a strategy that we'll get into detail right now. Tonight is the required public hearing on the zoning, and if any of you, so just to sort of clear the air, because I know there's been some misinformation out there. The proposal you're seeing tonight has nothing to do with the craft group. In fact, they asked us to be at the table with us to work on the zoning, and we said no, because we knew how it would go. We chose a location in town that we felt had the least impact on neighborhoods and had the most likely chance of being approved. It is not Ashcroft and that neighborhood. It is not on North Street. It's not the terminals. They did ask, and the board, if you watch the January 17th meeting, you'll see that the board said no, and we're proceeding with the district we're proposing. So the district we're proposing is up. I tried to look today to try to get a better way of describing it. I think it's in the general vicinity of the P10 parking lots. It's on that side of Route 1. Up against the Walpole line, and most of it is within the half-mile radius. On this map, you'll see the circle showing the half-mile radius. So that is the entire district. We did look at splitting up districts and having districts in other areas of the town, and after sort of doing some very informal canvassing of various residents, it was kind of like, let's just have it in one place, because if we start getting tricky and overlay it over an existing multifamily, you just don't know what could happen. And so we felt this would have the best chance. Barney's going to go in a little bit more into detail into the zoning bylaw, but here are the highlights. What we did is we took our existing bylaw and tried to not get too elaborate. We tried to work within our existing bylaw and tweak the zoning to allow it just in that district, which would be basically you'd need 32,250 for the square feet for the first dwelling units and an additional 1,750 for the others. And again, Barney will get into that. And that's my overview of MBTA Communities.